Selamat pagi Bapak dan Ibu. Kami mohon berkenan untuk Bapak dan Ibu yang masih duduk di kursi bagian belakang untuk bisa berpindah mengisi tempat duduk yang ada di bagian depan terlebih dahulu. Monggo. Ya, biar nanti bisa memudahkan yang lainnya juga bisa mengisi di bagian belakang. Silakan Bapak dan Ibu yang masih ada di bagian belakang bisa berpindah di baris pertama dan kedua terlebih dahulu, diisi di bagian depannya. Untuk tas merah yang sudah dibawa masing-masing bisa ditaruh di bawah meja masing-masing saja, jadi tidak perlu ada di atas ya.
Video yang The Great Malang area, which offers cool and comfortable weather, is a perfect location for learning, allowing students to keep growing and developing. Everyone will surely love this city. It is the dream place for all students from various cultures and countries. The University of Muhammadiyah Malang, UMM, is blessed with all sorts of natural splendours. This university is full of achievements. No wonder awards and acknowledgements keep coming from various institutions, both national and international ones.
Welcome to the conference. Selamat datang, Dr. Tongat, Dean of Faculty of Law.
Among others are the highest A-list institutional accreditation from the Indonesian National University Accreditation Body, BANPT, and the award for the leading university from the Department of Higher Education Regional the 7th of East Java, which was achieved 11 times consecutively. In the global level, UMM achievement is also as great. UMM has twice been awarded the Asian Energy Awards in 2009 and 2018. In 2010 to 2011, UMM also achieved 2-star university from the internationally renowned institution. In addition, UMM has also been an associate member of the AUNQA, the Asian University Association. UMM students are highly heterogeneous. They come from all corners of the nation as well as overseas. There are 11 faculties and 57 study programs offered in UMM, starting from the diploma level, undergraduate, graduate to doctoral programs. Among those, 4 of UMM study programs have been internationally accredited and certified by the AUNQA. Some of the list of faculty and study programs in this university are all faculties and study programs are equipped with high-standard laboratories, which are all centrally managed by the UMM Central Laboratory Office. UMM laboratories have achieved the International Standardization Organization (ISO) from the National Accreditation Committee, and so we are qualified to perform laboratory tests for other agencies such as companies or other universities. In addition to academic facilities, UMM also offers many business units which serve as the university income centres. Those business units allow the university to have more sources of income for its operational cost, thus we do not merely depend on the funding generated from the students. We have UMM Dome, UMM Hospital, Sarya Medika Hospital in Sumbawa, UMM Gas Station, Motorbike and Car Workshop, Micro Hydro Power Plant, UMM Sang Soya Apartment, UMM Rinjani Credit Bank, UMM Farm Agriculture Production Centre, UMM Sangkaling Recreational Park and UMM Kapel Garden Hotel. All those business units also serve as the applied laboratories in order to boost UMM students' entrepreneurship skills. As an internationally reputable university, UMM is proud to have conducted many international outreach programs with various academic activities such as seminars, conferences, research projects, as well as student, staff and faculty member exchange programs with numerous overseas universities and institutions. So far, UMM has established active collaborations with 111 universities, as well as governmental and non-governmental institutions from a total of 31 countries around the world. Among others are UMM students and lecturers embraces creativity and innovation in developing their research and academic works, as well as to perform community service programs. This enthusiasm for working and innovating has been the main urge for the UMM students of Communication Science major to renovate the slum area of Jolapan to be the colourful neighbourhood area, more commonly known in Indonesia as Kawasan Kampung Warna-Warni, which is renowned internationally, as well as to create the Tempenasor Green Neighbourhood, Kampung Hijau Tempenasaurus, located in Beji village, which is acknowledged by the Indonesian Museum of Record, MURI. On top of that, the robotic team of UMM has 3 times in a row won the International Robotic Competition in the US. UMM is also renowned for its energy independence. For more than a decade, UMM has established its own power plant, the Micro Hydro Power Plant. After gaining success in the university area, this power plant concept was expanded by establishing other micro hydro power plants in Sumba Maroon, Kamrasuku Village, Malang Regency, and in the Boonspring tourism area. This programme has successfully established 4,000 electricity connections in the local resident houses. Success starts from the courage to dream and to move forward for better change. Your steps today determine your roles in the future, to be students and graduates who are ready to actively work and contribute for the nation. Students today, leaders tomorrow.
Assalamualaikum warahmatullahi wabarakatuh. Good morning, ladies and gentlemen. Welcome to the second International Conference on Law Reform entitled Narrating Law Reform in Asia Between Fulfilling Human Rights and Restorative Justice, held by University of Muhammadiyah, Malang. Before we start today's agenda, we would like to present to you traditional dance performance from Sanskerta students community of UMM. This dance tells the story of young girls who are growing and developing with various expressions that are channeled through agile movements that follow the rhythm, be it hand, foot, or hip movement. This dance is an entertainment for the community as a form of love to the environment. Ladies and gentlemen, please enjoy the dance from the screen and give a round of applause to Genjering Party Dance. So please give a round of applause one more time to Genjring Party Dance, ladies and gentlemen. Well, thank you. Good morning, ladies and gentlemen. The honorable keynote speakers of today's agenda, Professor Hikmahanto Juwana, the Honorable Vice Rector of Academic Affairs, University of Muhammadiyah Malang, Professor Syamsul Arifin, the Honorable Assistant Rector of International Accreditation and Academic Development, University of Muhammadiyah Malang, Associate Professor Suparto, Dean of Faculty of Law, Dr. Tongat, Head of the Committee, Mrs. Fitri Esfandiari, and our speakers, Dr. Hilaire Tegnan, Dr. Petra Mahy, Dr. Muhamad Helmi Said, Dr. Fifik Wiryani, Dr. Catur Wido Haruni, and all of the participants and audiences. First of all, we would like to say welcome to you all to this very special occasion, the second International Conference on Law Reform, entitled Narrating Law Reform in Asia, Between Fulfilling Human Rights and Restorative Justice, held by University of Muhammadiyah Malang. Before we go, we would like to ask you to please turn off the microphone during the conference. Well, ladies and gentlemen, the first agenda is reciting Holy Quran. Mr. Albar Kati Arhami, time is yours.
Assalamualaikum warahmatullahi wabarakatuh. A'udzu billahi minasy syaithanir rajim. Bismillahirrahmanirrahim. Ya ayyuhalladzina amanu idza qila lakum tafassahu fil majalis إذا قيل لكم تفسحوا في المجالس فافسحوا يفسح الله لكم وإذا قيل انشزوا فانشزوا يرفع الله يرفع الله الذين آمنوا منكم والذين أوتوا العلم درجات Sadaqallahul azim. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam.
Thank you for the recitation, Mr. Al-Barkati. Now, ladies and gentlemen, we would like to ask you to stand up and sing Indonesia Raya and Muhammadiyah anthem together. Ladies and gentlemen, please stand up. Indonesia Raya. Muhammadiyah Anthem Sang Surya. Ladies and gentlemen, please be seated. Now, ladies and gentlemen, let's listen carefully to the welcoming speech from the head of the committee, Mrs. Fitri Esfandiari. We invite you to give the speech.
Warahmatullahi wabarakatuh. A'udzu billahi minasyaitonir rajim. Bismillahirrahmanirrahim. All praise is due to Allah, the Lord of the world, the Master and the Creator of everything in the universe. Salawat and greetings may be poured out into our Lord Muhammad sallallahu alaihi wasallam, who has brought us to all to Dinul Islam. The Honorable, the Vice Chancellor for Academic University of Muhammadiyah Malang, the Honorable Assistant Rector for International Accreditation and Academic Development, the Honorable Representatives from the International Committee of the University of Muhammadiyah Malang, the Honorable Head of Development of Scientific Publication Board, the Honorable Dean of Law Faculty, University of Muhammadiyah Malang, the Honorable co-host from Gorontalo State University, Jakarta Islamic University, University of Muhammadiyah, Surabaya. Good morning. Welcome to the second international conference held by University of Muhammadiyah Malang with the theme Narrating Law Reform in Asia Between Fulfilling Human Rights and Restorative Justice. This conference aims to discuss about how to contribute the development of legal policies through the strengthening of human rights, and to contribute ideas that can be used for formulate international and national law both in Asia and internationally. Thus, reveal, touch, and provide alternative solutions for global problems in the field of law, especially in the new normal era. The participation in this activity was both from outside and inside within the country. And for publication in this activity, namely reputable journals and proceeding at the Atlantis Press. Please welcome the speaker are from Hikmahanto from University of Indonesia, Dr. Hilaire Tegnan from William and Mary School, USA, Dr. Petra Mahy from Monash University, Australia, Dr. Muhamad Helmi from University Kebangsaan Malaysia, and Associate Professor Dr. Fifik Wiryani, University of Muhammadiyah Malang, Dr. Catur Wido Haruni, University of Muhammadiyah Malang. I would like to say thank you very much for the entire committee for this international conference who had extraordinary work for prepare this occasion, and especially to the Dean of Law, Faculty University of Muhammadiyah Malang. There must be some weaknesses holding this international conference. Hence, we do apologize for the inconveniences. We hope that this conference will be fruitful for the participants in conducting a great research. By this, I, who represent the entire committee, hope that this conference beneficial to all. Thank you. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you for the welcoming speech, Mrs. Fitri. The next speech will be delivered by Assistant Rector of International Accreditation and Academic Development, University of Muhammadiyah Malang, Associate Professor Suparto. We invite you to give the speech and open this conference.
Assalamualaikum warahmatullahi wabarakatuh. Alhamdulillah, today we are able to be here because actually I didn't expect that I was invited to participate in this program, in this prestigious program. Anyway, first I would like to acknowledge the Vice Rector for Academic Affairs, Professor Syamsul Arifin, and then the Deans and Vice Deans of Faculty of Law, the Head of Publication, Academic Publication, Scientific Publication of Muhammadiyah Malang, Ibu Fardini, and also the committees, the participants who have been participating in this program. For those who are not from this university, welcome to this university, University of Muhammadiyah Malang. Physically, for some of you might be, and virtually for most of you. I am delighted to be able to make contributions today in today's conference, which provide us with an important opportunity to highlight the fulfilling human rights and restorative justice, as stated on the theme of this conference. Narrating law reform in Asia between fulfilling human rights and restorative justice. Between these two terms, human rights and restorative and justice, I would like to underline only the second, the restorative justice. And between these two terms too, I will specify only on one, on the second, justice. Because I do not have the expertise on this area. I am not equipped with, for example, the understanding among restorative justice, and then I heard sometimes rehabilitative justice, and then sometimes maybe you have another term using retributive justice or something like that. Not at all. I am not an expert of that. Ladies and gentlemen, we all realize with complete understanding, justice is the basis of orderly human being. Therefore, it demands a regulation that can stand for harmony between individual interests and the interests of society. In defending or opposing laws, policies, decisions, and actions, people participating in demonstration, for example, do it in the name of justice. Persons involved in every agitation always raise the slogan, "We want justice." Just to refresh our mind, the word justice has been derived from the Latin words. Jangere originally means to bind or to tie together. The word just itself also means tie or bonds. In this way, justice can be defined as a system in which men are tied or joined in a close relationship. In such, justice means bonding, joining, or organizing, or harmonizing different values and needs into a right or fair order of relationship. It might look simple and easy to understand based on the definition. However, in practice, it is on the contrary. Justice is a complex concept. Justice is not about what someone gave to you, but it is about what no one can take from you. This is justice, in my opinion. People are not born knowing what it is. It takes enormous effort to arrive and at the respect of the other people that this word implies. The implications also goes to this conference, in my opinion. This activity will be of high significance when it is able to go down to earth, not only flying on the sky. Most of the conclusion and suggestion, recommendation, for example, must be feasible to be implemented in the FUCA area: variety, uncertainty, complexity, and ambiguity. For this purpose, it is important to invite and to listen to another sound, in quotation mark, not only from academicians. Because when only one group of people gather together, the result might be on the contrary, sometimes. For example, when there are too many policemen, there will be no liberty. When there are too many soldiers, there will be no peace. Even when there are too many lawyers, there will be no justice. My concern is that when there are too many academicians and professors, there will be no conclusion and no recommendations. I hope it will not happen. I hope that the final conclusion will be able to spark the heads of academicians and professors and touch the hearts of lawyers and judges. Today will be the opportunity for us to exchange ideas and good practices. Thank you, finally, thank you for those who have been working sincerely to make this event get on the right track. Especially Vice Rector 1, Professor Syamsul Arifin, who has monitored and given guidance from day to day, the deans and vice deans, the head of scientific publications, and also, of course, the committee. This has been worked very hard for this activity. Thank you to the keynote speaker, Professor Hikmahanto, plenary speakers, and all the audience. For those who come from outside UMM, thank you for visiting us, either physically or virtually. Your coming will, hopefully, your coming here to UMM will transform your perceptions about UMM. From maybe before coming here, you are stranger for us. But when you have been here, I hope you consider us as a friend. And when you consider us as a friend, we will treat you as a family, the family of UMM. Thank you. Assalamualaikum warahmatullahi wabarakatuh.
We invite Mr. Suparto to beat the gong as a sign of the opening ceremony, accompanied by Dean of Faculty of Law. We invite Dr. Tongat to come to the stage. Ladies and gentlemen, please give a round of applause to the beating of the gong. And the beating of the gong that we just witnessed together signaled the end of the opening ceremony of this conference. And hopefully this conference can be useful for all of us. Thank you, Mr. Suparto and Mr. Tongat. Now, ladies and gentlemen, let's move to the main agenda. The section will be started by the speech of our keynote speaker, Professor Hikmahanto Juwana. Time is yours.
Well, thank you very much, and a very good morning to you all. Assalamualaikum warahmatullahi wabarakatuh. Salam sejahtera for all of us. First of all, let me congratulate the Faculty of Law, Universitas Muhammadiyah Malang for conducting this event. The Honorable Assistant Rector for International Affairs, the Dean, Faculty of Law, Universitas Muhammadiyah Malang, a good friend of mine, Dr. Tongat SHMH, and other dignitaries in the audience. Let me start by saying that Indonesia has changed. Indonesia, since 1998, has entered into a new era. Today's era is different, of course, from the previous era. Today's era, there are 4 basic things that need to be considered. One is an issue of human rights. Second, law. Third, democracy. And fourth, the voice of the people. These 4 things was not the era of the day prior to 1998. But today, we see that people are voicing their concern. And democracy is practiced like any other democratic countries. Thirdly, we have law and enforcement of that law. And of course, lastly, respect of human rights. However, we, Indonesia, see challenges. For example, in the field of law, we have problems of how we make our laws, since Indonesia is a very huge country. A law that is made, say, in Jakarta, an undang-undang, may not be enforceable in other parts of Indonesia. And it is because of the infrastructure of the legal system which is lacking in other places. Jakarta is not a representation of Indonesia. Jakarta and big cities in Indonesia. And we have also problems with the human resources within our legal system, be it the police, the prosecutors, the judges, even the correctional officers. And we do have problems whereby the state cannot afford to give welfare rightfully to our law enforcement agencies. And this has created a problem in Indonesia on how we enforce the law. Because, as I see it, there's a challenge of integrity. Some of the officials, not all of them, of course, receive bribes. And corruption is prevailing still in Indonesia. So when we want to uphold democracy, when we want the people to voice their concern, the question is whether the law enforcement agencies can deliver those so that people feel comfortable in voicing their concern, in practicing democracy, without fearing that they will be arrested, and at the end of the day, sometimes they have to pay a sum of money to get released. And the problem that I see that faces Indonesia is, even though ideally we want to practice democracy, however, we cannot practice that in a very true sense, because not only the officials that having problem, but also the society, the Indonesian people, they practice their democracy too extensively, as if there are no laws and regulations that will tie them so that they will observe the laws and the regulations. Sometimes, if I look at the comments from the netizen, they sometimes goes beyond what can be said within the laws and regulations. And of course, this leads to the issue of human rights. Whether the basic human rights in Indonesia can be exercised and implemented by the people. From the government side, of course, they will say they can, of course. But the problem is, where is the boundaries between practicing the basic human rights of voicing concern and violating certain laws and regulations? This has been an issue. And recently, the government and the law enforcement agencies introduced what is referred to as the restorative justice in Indonesia. Not all complaints by someone will be followed up by the enforcement agencies. We do not want the taxpayers' monies goes to a case that does not have a solid grounds, a solid arguments. Sometimes when people complain to the police and would want the prosecutor's office to prosecute a certain people, it is not because their rights has been violated, but it is more of a grudge that they want to use the public officials, especially the law enforcement agencies, to perform that grudge. So this is a problem. That's why restorative justice has been introduced. But then again, the problem of restorative justice faces a problem, because those who are complaining to the police, complaining to the Attorney General's office, wanting the Attorney General's office to prosecute, they are not satisfied. They want justice to be served to the person who they complained. They want to see the person they complained end up in jail. So mediation sometimes fails. And of course, the issue will linger on. And sometimes along the line, there is those, not all of them, of course, the law enforcement personnel who wants to take advantage of the issue. So the question is, how are we going to implement the restorative justice? Of course, from the government perspective, they do not want to see a lot of people end up in jail, because in Indonesia, we understand the jail have been over capacities. There are a lot of criminals who end up in jails, sometimes because of petty criminals. This, of course, the challenge that needs to be addressed. Now, I understand that when we are discussing about restorative justice, this does not apply only in one branch of law, such as criminal law, but it also applies to various branches of law. I myself, who have areas of specialization in international law, see restorative justice can be used after a certain armed conflict ended, be it between the government and the insurgents, or between governments of states. And in this event, in CLAR, many of you, the scholars who have done your research, will present from the various branch of laws on how, on the one side, human rights are still respected, but on the other side, the restorative justice will be delivered. Of course, as the Assistant Rector mentioned, Dr. Suparto, that a lot of good things are written. But the question is, can those be practiced, can be implemented? And this is a challenge for us scholars on how what we have in mind to be practiced and implemented in reality. And this is where an issue of law cannot be isolated from other fields of study, such as sociology, psychology, and many other branches of sciences. This is where the legal scholars have to take into account various aspects in society so that we as an academician have the responsibility not only suggesting, giving recommendation, or even giving
Professor Hikmahanto, I'm sorry we cannot hear your voice. Could you please turn on the microphone? Sorry, we still cannot hear the voice, Mr. Hikmahanto.
Okay.
Okay.
Can you hear? Can
Yes.
you hear me now? Yes.
Yes, thank you. Please continue the
Oh,
speech.
sorry. As I was saying, scholars in Indonesia should pursue when they write their research and publish it in a journal, not for the purpose of getting credits or a fulfillment of requirement to do your PhDs. But please, if you do your research and then you have written in a paper and publish it in a journal, you do it because you want other people around the world to acknowledge your research. And hopefully they will quote what you have written, so that a publication from Indonesian scholars can be highly regarded by other scholars around the world. And this is very important because we have to go to the next level when we are publishing our research in a journal. As I mentioned, I go to various parts of Indonesia, universities, and then I see that a lot of faculty members, they want to write in a journal because they want to have promotion, to do to fulfill the requirement for the PhDs. But they don't have the motivation that they need their voice to be heard around the world. So I hope in today's presentation, and we are discussing about human rights and restorative justice, you will receive comments from your peers. And based on that comments, you will improve your papers before publications. And I hope that this is not going to be your first and last papers you need to be presented, or you will write, you will publish. But I hope that there will be more and more papers and publications from you, the Indonesian scholars, especially the legal scholars. So with that, I would like to conclude. 3 things. 1, yes, Indonesia has go far beyond in practicing human rights. But as I mentioned before, we have some challenges that we need to face, be it the law enforcement agencies, the law itself, and how we practice democracy in Indonesia. The second is the restorative justice. Many see this as a breakthrough. Breakthrough because the awareness, the legal awareness of Indonesian society is increasing. Sometimes a simple issue will be reported to the police. But as I mentioned before, it is reported not because they want the law to be upheld, but it is because of personal grudge. And then they use the law enforcement agencies to satisfy their personal grudge. And lastly, this is a message to you all the scholars. I hope that your research will be published, and once it is published, it will be recognized by scholars from other countries, and then hopefully your research will be quoted. And that is a satisfaction feeling that you will get as a scholar. With that, I would like to end my keynote speech and again have a fruitful discussion on your papers, and also I hope that INCLAR will continue not only last year, this year, but also next year's and the years to come. Again, congratulations to the committee and Faculty of Law Universitas Muhammadiyah Malang. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh.
Thank you, Professor Hikmahanto Juwana, for the very insightful speech. Please give a round of applause one more time for Professor Hikmahanto Juwana. Bapak Ibu. Well, ladies and gentlemen, now let's head to the all gorgeous speakers of today's conference. But before that, I would like to greet our moderator who will lead this section, Mr. Hasnan Bahtiar LLB MA. He is a lecturer of University of Muhammadiyah Malang, who's already completed his postgraduate degree from Australian National University. Mr. Hasnan Bahtiar, time is yours.
Thank you, Cha. Ladies and gentlemen, Assalamualaikum warahmatullahi wabarakatuh. Thank you very much for joining us at this distinguished forum of conference, the Faculty of Law, the University of Muhammadiyah Malang, Indonesia. So we have the second INCLA, International Conference on Law Reform. The special issue that we will take over is human rights and restorative justice, as discussed before by Professor Hikmahanto Juwana. Before we start the program, I'd like to remind you, all participants, to mute your microphone during the panel discussion. The exception is for a speaker, indeed. And the program will be divided into 2 parts. The first will be discussion with Dr. Hilaire Tegnan, and Dr. Petra Mahy, and Dr. Muhammad Helmi Muhammad Said. And the second will be Dr. Fifik Wiryani and Dr. Catur Wido Haruni. Ladies and gentlemen, each speaker will have 12 minutes, once again 12 minutes for delivering a presentation. Then we have a Q&A session. For the Q&A session, you can write down on the Zoom chat room, chat box, sorry. Please write your name, the speaker's name, and your question. So the special topic that we will discuss is narrating law reform in Asia between human rights and restorative justice. Let's start the first session of this program. Ladies and gentlemen, Dr. Hilaire Tegnan is a scholar at William and Mary Law School, Williamsburg, Virginia, the United States of America. He obtained his dual bachelor and dual master degree in criminology from the University of Paris, Panthéon-Sorbonne, and University de Cocody, Abidjan. He achieved his PhD in law from Utrecht University, the Netherlands, and Andalas University, Indonesia. He has a lot of academic publications. According to the Google Scholar analysis, the most influential work that Dr. Hilaire has is The Legal Pluralism and Land Administration in West Sumatra, the implementation of the regulations of both local and Nagari governments on communal land tenure, published by the Journal of Legal Pluralism and Unofficial Law, Routledge, New York, 2015. Then we have Dr. Petra Mahy. Dr. Petra is a lawyer, an anthropologist, and a senior lecturer at the Department of Business Law and Taxation, Monash University, Australia. Her research interests fall in the disciplines of socio-legal and regulatory studies. She is a chief investigator on the ARC Discovery Project entitled Formal and Informal Regulation of Labor Disputes in Southeast Asia. She obtained her Bachelor of Arts and Bachelor of Laws from Monash University in 2005 and Bachelor of Asian Studies with the first class honors and the University Medal from the Australian National University, Australia. Dr. Petra's PhD thesis was completed at the same university in 2011 on the topic of gender equality and corporate social responsibility in mining, an investigation of the potential for change at Kaltim Prime Coal, Indonesia. And the last but not least, Dr. Muhammad Helmi Muhammad Said. He is an advocate and a solicitor, Malaya, non-practicing, and a senior lecturer at the Faculty of Law, International Islamic University of Malaysia, IIUM or UIA. He obtained his Bachelor of Laws and Bachelor of Laws with specialism on Sharia, both with honors from the same university. Master of Criminal Law and PhD from the same university, IIUM. His specialization is family justice, including woman and child issues, procedural laws, criminal and Sharia, private international laws, and statistics for legal studies. His current work with Ibu Tinuk Dwi Cahyani, actually, she is academic at the Faculty of Law, the University of Muhammadiyah Malang, and Muhammad Sayuti Hasan is equality among the community for participation in the efforts to prevent bribery in Indonesia. Ladies and gentlemen, I'd like to invite, firstly, Dr. Hilaire to speak. Please, Dr. Hilaire.
Thank you very much for these wonderful introductions. I can see in there more information about me, so I want to congratulate you for that beautiful work. I would like to take this opportunity to thank the Universitas Muhammadiyah in general, especially the rector and the vice rectors. I also want to thank the community for giving this opportunity to express myself in this wonderful event. Without wasting too much time, I would like to proceed to what I have to present today, which is talking about restoration. But before I move forward, I want to share my screen first to make sure
recording
my
in
screen is
progress.
shared. Okay. Allow me to share my screen. Can my screen be read? Can you see it? All right, so as those who preceded me, the keynote speaker, the vice rector, almost touched on a little bit about these subjects. What I will say is given a perspective from a different angle, but it won't be very much different from what has been already said. And I would like first to begin by highlighting or giving the key parts or the major aspects of my presentation. I'll be brief, so we can maximize time and allow other speakers to have the say, since I only have 12 minutes. So bear with me here, and probably in the question sections we'll maybe talk more about these issues. So as I said, the aim of my presentation, first it will be, I discuss the implementation of human rights and restorative justice in Indonesia, because I've done like the master ceremony just introduced. I did a lot of research in Indonesia, so I'm not saying that I'm an expert when it comes to Indonesia, but I have a great deal of knowledge to compare, to discuss with my peers. So having said that, I'll move forward to highlight the key elements of my presentation. So number one, I'll talk about the legal reform a little bit because of the time constraints, and also talk about the human rights issue in Indonesia and globally, and also, of course, the restorative justice and the era reformasi, because we cannot talk about these issues that are very crucial without mentioning era reformasi. So by doing this, ladies and gentlemen, my intent is to address the questions as to, do human rights principles affect the implementation of restorative justice in Indonesia? So what I'm trying to portray here is, I'm trying to see whether or not the two concepts work together to improve the quality of justice in Indonesia, or they fight one another to weakness the access to justice in Indonesia. Next will be, from the research I've conducted, I found out that to build a nation respectful, when I say respectful here, I mean a nation, a country, whereby you can find a strong implementation of human rights and the rule of law, is the implementation of restorative justice. So this is a conclusion. Yeah, I know. Yeah, we used to say don't jump to the conclusion, but I want to put my conclusion up front, so we can have an idea of where I'm heading and what I want to achieve here. So, as I said, restorative justice as an alternative to retributive justice. As the vice rector, if I'm not mistaken, even though my camera was off, but I was very much listening to what the vice rector said. Yeah, he mentioned the retributive justice, rehabilitative justice, and also my subject matter today, which is restorative justice. So, as I said here, my research concludes that retributive justice is inconsistent with human rights. It is inconsistent, and as I proceed forward, I'll give what I mean here by this, ladies and gentlemen. So next, I'll give you a little background, introductory aspect of what I'm about to say. So as you can see here, the promulgation of Universal Declaration of Human Rights and Human Dignity, which started in 1947, has pushed countries, nations around the globe to adapt, to modify the constitutions or the legal system to comply with this concept, which is human rights. So the starting point is the Universal Declaration of Human Rights and Human Dignity. And also the other aspect that I would like to elucidate here to you, ladies and gentlemen, is in Indonesia, these principles of human rights are provided in the preamble to the 1945 Constitution, which is refers to as Undang-Undang Dasar 1945. Which was the original constitution, since it's been, ever since it's been amended 4 times in 1999, 2000, 2001, and the last was in 2002. And this constitution said, the preamble says the government should protect all the people of Indonesia. So this is a constitutional right, human right. It's a divine right and also a constitutional right. So it has 2 legal grounds here: the preamble and also some following provision within the same constitution. And as I proceed here, I would like also to highlight the fact that the principle of human rights are also enshrined in Pancasila. In Pancasila, as you can see, you have it's philosophical and the doctrine based on 5 pillars in Indonesia. So one of these pillars are a republic built on sovereignty and on the belief of one God, a just, civilized humanity, a unity of Indonesia, and democracy. So as you can see here, the second point, it points out here justice, a just and civilized humanity. Humanity here means the compassion, the human rights, and all of this. So as you can see here, the foundation of the Indonesia legal system is already, it already has human right elements right from the beginning, the preamble to the constitution itself, to Pancasila. So it's already in there, as I just pointed out here. Moving forward, what I would like to point out again is, since the end of the Second World War, you've seen a lot of the expansions of globalizations, which is, it's like I said, like the human right, the Universal Declaration of Human Rights. Globalization also has influenced the legal process in many countries, including in Indonesia. So these globalizations gave birth to challenges and also opportunity for the protections and the promotion of human rights, justice, and the rule of law. Talking about the rule of law, ladies and gentlemen, I think it's important to mention that the constitution that I referred to just now specifically the Article 1, Section 3 says Indonesia is a rule of law country. So it says that clearly Indonesia is a rule of law country. This is a big package. It is a bold statement. As we know, rule of law also involves human rights and democracy. It's a big package. So I want to touch on a little bit on that constitutional provision. Why did I mention in here? Because of the importance of these constitutional provisions. And also, in addition to that, you have several events that contributed to the advancement of human rights and rule of law since the fall of President Suharto. So what I'm trying to do here is to give a picture of how we got in here, the background, the legal background of the issue. So I'm talking about the reforms, how did they occur, and how do they relate to the implementations of justice. So as I proceed, I only hope that I'll make sense, that I will help maybe you understand and follow through to what I'm doing here. And also you have the introduction of human rights provision within the 1945 Constitution. So if I'm not mistaken, you have the Article 23 that is incorporated in the 1944 Constitution. So Indonesia from a long time ago has already set the stage for human rights. So it's not a new debate. It's not new to the Indonesian legal systems and constitution. And also you have these challenges, this reform, you have government accountability, which means the government no longer can just violate the right of the people and just get a free pass. Now there is accountability of the government now. That's why you have judicial review, you have impeachment, all these things. The people are asking their government to be accountable. And this is a very, very big move, and it's evidence that human right is somehow is protected under the 1945 Constitution. And also you have, like I mentioned, judicial review, impeachment, and last but not least here, you have decentralization. This is very important too, because through this decentralization, you have power that used to be centralized being given to the people down the line of the command. So you have the government that is no longer the only the only entity having the power. The power now goes to local government, and it is divided into many branches. So this proves that the people are given the opportunity to decide for themselves. This is very important to point out here. And as I move forward, I'd like to give some elements here of the era reformasi. So era reformasi, I'm not going to say, give a definition here because obviously the audience knows better than I do. But I would like to give a key point here that tells how human rights are very taken into consideration, very important to the Indonesian people and the Indonesian government. First one is, you can see here, the establishment of KPK, which is very important to fight corruption. So one way to respect and preserve the rights of the people is to fight corruption. As was pointed out earlier by a professor, the name is, I just forget, but he made a very, very brilliant point by saying corruption is it's everywhere, it spreads. You have academic corruption. When it talks about publications and stuff like that, this also can be referred to as academic corruption. And also you have...
Dr. Hilaire, you have 1 minute.
Oh my, okay. Well, I'll be quick. So I'll skip this part and go straight to justice. So you can see here the three types of justice. We have punitive justice, we have rehabilitative justice, and restorative justice. I'll skip the two other ones and talk directly about the restorative justice. Why is it important? Why is it the perfect, the ideal tool to respect and implement human rights? Because restorative justice here, it gives the opportunity to the victims. It puts the victim in the center of the attention, not the offense, but the victim. How can it be reparated? How can he be satisfied by the offender? So because of the time constraints, I won't very much elaborate on that because obviously I don't have too much time here. And here, you see here, restorative justice has been suggested for with a view to alleviate shortcutting of criminal justice. So it is the key aspect of the entire justice movement to put the victim in the center, to seek for reparation, to seek for mediation. And when you mediate, you are taking into consideration the right of the people, the human right of the people. This is why I reached that conclusion by saying retributive justice, it only seeks to avenge. It only seeks to bring about a type of justice that is not taking care of the needs of the victims, but how can the law be applied to a certain crime to prevent more crime? By here, has the victim been satisfied? Has it been repaired, the suffering, the emotional distress? Has all these things being fixed? So this is the course to take, and I think restorative justice is a perfect way to go. Now, thank you very much.
Well, thank you, Dr. Hilaire. Indeed, you are one of the best Indonesians who has a specialization in legal studies.
Thank you, I appreciate that.
Now, we will turn to Dr. Petra Mahy. Please, Doctor.
Thank you. Hello, everyone. I'll just wait to be able to share my screen. I think, great. Okay, good morning, everyone, and thank you very much to the organizers for the invitation to present at this conference on law reform and human rights. It's actually been almost 20 years since I last visited Malang, but it's really nice to be meeting people from UMM, even if only virtually via this conference today. So I think this conference is a perfect opportunity to present my paper on Indonesia's omnibus law on job creation, legal hierarchy, and responses to judicial review in the labour cluster of amendments. So my theme of my paper is very much on law reform here and also on human rights. I'm sure I probably don't need to explain the controversies surrounding omnibus law to this audience. Most of you will be very familiar with it already. But just as brief background, the law was signed by President Joko Widodo on the 2nd of November last year, and it is now known as Law Number 11 of 2020 on job creation. Enacting this law was a signature policy of President Joko Widodo, and it is largely aimed at reducing overlapping regulation, lowering the cost of doing business in Indonesia, and raising Indonesia's ranking on the World Bank's Ease of Doing Business Index. Although, ironically, I note that the World Bank actually abandoned its Doing Business Index just last week. The controversy about this law arises in part from how it was enacted. So it was enacted very quickly, without much public consultation, and it was pushed through during the COVID-19 pandemic while it popular protests. It's also controversial because of the changes in the law that it introduced. That is the introduction of a new business licensing framework and then simultaneous amendments to existing national laws, covering a very wide sweep of issues, including, but not limited to, environmental protection, spatial planning, special economic zones, small and medium enterprises, land rights, transport, energy, agriculture, fisheries, and taxation. But perhaps most controversial of all are the amendments to the labour law, many of which do lower worker protections. And I'm really only concerned...
Excuse me, Dr. Did you already move the slide?
Not yet. I'll do that in just a moment. Thank you.
Sorry. Yes, please.
So I'm really only interested here in the labour cluster of amendments in this paper. And I also take account of the implementing government regulations in relation to the labour cluster, which were issued in February of this year. So my next slide. So what we are hearing about this law from academics, activists, and other commentators is some pretty compelling arguments about the omnibus law being a symptom of or evidence of Indonesia's recent democratic decline or illiberal turn. So this is the kind of language that is coming through in the political science analyses of Indonesia over recent years. So the question I've been pondering is whether the labour cluster of amendments provides evidence for this or not. And my answer is mostly yes, but there are also some complicating factors here. The devil is in the legal detail, as we might say. And there is quite a bit more going on below the surface of the headline-grabbing reductions in worker protections that has been mostly associated with the law on job creation. These reductions are important and worrying, but the argument that I want to make today is that much of the discussions in the media about the law on job creation, and also a lot of the academic commentary, has been majorly simplified and also at times misleading. And much of that devil in the detail in the legal detail, really only emerged with the implementing regulations, so the government regulations that were issued in February of this year. And I've spent a lot of time going back and forwards between the original law number 13 of 2003, so the major labour law or Manpower Act, and the new law on job creation, and the new implementing regulations. I'm trying to understand exactly what has happened, what has changed, what hasn't, and figuring out why some of those changes have occurred. For me, a couple of things stand out. Firstly, a number of the amendments respond to Constitutional Court judicial review decisions in relation to law number 13 of 2003. And secondly, there's been a major rearrangement of labour law rules or labour rules within Indonesia's legal hierarchy. So I'd like to explain these two issues in more detail in a moment. As I mentioned, a number of the labour-related amendments introduced by the law on job creation and its implementing regulations are deregulatory or flexibilising in nature, so they are pro-employer. They have reduced restrictions in relation to time limits on fixed-term contracts and the types of work that can be outsourced. They've reduced severance pay calculations and increased the maximum number of overtime hours that can be worked per day. Some exemptions have also been introduced for micro and small enterprises, including from needing to pay the minimum wage, and the right to long service leave has also been removed from the law. But some other changes lean in the opposite direction as well, perhaps to lessen union opposition to those pro-employer amendments. So, for example, compensatory payments to workers when their fixed-term contracts end have been introduced, as have new penalties for employers who pay wages late and new criminal sanctions for non-payment of severance pay. Also, the new unemployment social security scheme also aims to partially shift the burden of dismissal costs away from employers to the state. So I've partially put this in the pro-worker column here. Now, I've heard various predictions about the likely impacts the likely impacts of these changes. Many people expect an increase in outsourcing. Some worry that businesses may restructure in order to appear to fit the category of small and micro enterprises in order to avoid paying the minimum wage. Others worry that the new fixed-term contract compensation payments might push employers towards using casual daily labour instead of fixed-term or permanent employment. It's probably too early to say yet how employers and how other actors are going to react. And there's obviously going to need to be a lot of empirical research in the future to try to understand the real-world impacts of these contradictory and interacting changes in the law. But then we get to the issue of legal hierarchy. And as I'm sure you are very well aware, Indonesia has a hierarchy of legal instruments, reading from the top, the 1945 Constitution, as was mentioned by the previous speaker, then decrees of the People's Consultative Assembly, followed by laws, undang-undang, then government regulations, presidential regulations, provincial regulations, and then local district regulations. Now, when Law Number 13 of 2003, the labour law, was enacted back in the early-ish Reformasi period, that law amalgamated, systematised, and importantly upgraded a lot of existing ministerial decrees and regulations that had existed in the New Order period, so they were upgraded to the level of law. And although the labour movement wasn't necessarily happy with the law, we might still see that upgrading process as being a strong indication of the Reformasi democratisation era of that time. But in the law on job creation, many substantive rules and calculations have been downgraded to the level of government regulations. And this does make some logical sense in that we have broad principles found in the law, in the undang-undang, and then the details are found in the regulation. But it also gives rise to two key concerns. One is that government regulations are the domain of executive government, not the legislature, and so they are much easier to change in the future. So severance payment calculations, for example, could become much more subject to change. The other problem is that it pushes these regulations out of the judicial review jurisdiction of the Constitutional Court to that of the Supreme Court, which has historically tended to be much less likely to uphold judicial review challenges. There also has been some upgrading going on in the law on job creation, particularly in relation to the controversial 2015 government regulation on wages, which took away union roles in minimum wage setting in Indonesia. These rules have been largely upgraded to the level of law now, although the formulas for wage calculations are still found in the new government regulation. So that was the legal hierarchy issue. Now I want to turn to discussing the responses to the Constitutional Court within the law on job creation. As I'm sure you know, the Constitutional Court has the power to review laws, to review undang-undang, as to whether they accord with the Constitution. And the main law, Law Number 13, 2003 on labour, has been challenged a total of 31 times since it was first enacted. And of those 31 cases, 12 were upheld or partially upheld. Meanwhile, of course, we also know that the Supreme Court can review lower level regulations, but at least in relation to labour cases, it has been very reluctant to exercise its judicial review powers, and there has been a much greater failure rate of challenges in Indonesia's Supreme Court. What we can see in the law on job creation is that of those 12 upheld cases, they've been mostly incorporated into the new law. So this can be seen as being largely a positive sign for Indonesian democracy, in the sense that the role of the Constitutional Court is being affirmed by the legislature. Even where the court's decisions have been directly overridden by the law, well, at least there is a dialectic occurring between court and legislature. But when you look down at the detail of this, there are also a couple of anomalies. So a couple of strange things that have occurred. The first is that there was no response in the new law to the 2009 union bargaining case. So this was a constitutional court case which concerned Article 120 of the 2003 Labour Law, which gave the union with more than 50% representation in an enterprise the right to bargain collectively. The Constitutional Court provided a conditionally constitutional ruling, allowing up to 3 unions with at least 10% membership to be proportionally represented in collective bargaining. And the court at that time, in 2009, also recommended legislative change to this article in order to clarify its meaning. But the law on job creation has not done this. It has overlooked this case, thereby leaving the court's interpretation in place. The second anomaly, the second strange thing that's happened, relates to dismissal for criminal misconduct. And this arises from one of the earliest reviews of Law Number 13, 2003, the earliest constitutional court cases from that era. And in that case, the court held that employers could not dismiss a worker until criminal proceedings had taken place due to the presumption of innocence until proven guilty. In the law on job creation, all mention of the ability of an employer to dismiss a worker for serious misconduct has now been removed. So there has been a response to the Constitutional Court. But instead, in the law, there is now a general permission to dismiss a worker for contravention of their contract terms, so of their individual contract, their collective bargaining agreement, or company rules. Then, when we look deeper at the implementing government regulation, a distinction has now been drawn between an ordinary contravention of contract rules and a contravention which is urgent, or bersifat mendesak, to use the Indonesian. An ordinary contravention requires 3 warning notices and has an attached right to some severance payments. An urgent contravention, though, does not require warning notices, and there is no right to any severance payment. The definition of bersifat mendesak is not included in the main part of the government regulation. We have to look further down to the elucidation, to the penjelasan, to the government regulation. And that's where we finally find the list of criminal behaviours such as theft, embezzlement, drunkenness, and use of narcotics, among others. And these were the very criminal behaviours that were originally listed in the 2003 Labour Law. So what's happened is quite complex here. The new law on job creation has tried to shift this form of dismissal into the civil law realm. So it's no longer criminal, it's civil. But it also seems to be trying to hide what it's done by putting it in the lower level regulations. And my guess is they've done this in order to try to prevent a constitutional court review of these particular provisions. Okay, so overall, that was a lot of complex information. Yes, hopefully you've caught it. But overall, in terms of arguments about democratic decline, the changes in the labour cluster seem to have undone much of the upgrading of ministerial regulations to law that occurred in the early 2000s. And a lot of those rules have now been put back in the domain of executive government, which makes them more susceptible to future change. And I think that that downward movement in the hierarchy is also shifting these rules outside of the review jurisdiction of the Constitutional Court into that of the Supreme Court, which, as I mentioned, has a much lower record of accepting judicial review challenges. We also see that the Omnibus Law and the government regulations were almost certainly drafted as an integrated package, which decided ahead of time where particular rules would be placed in the hierarchy of legal instruments, thereby blending legislative and executive powers. And I think this is very worrying for Indonesian democracy and the principles of separation of powers. In terms of the responses to the Constitutional Court decisions, they've mostly been positive. So this is why my argument is a little murky. But as mentioned, there are also some anomalies, which don't really make sense, some strange things that have been happening there. And of course, just to mention, there are still many challenges to the law on job creation pending in the Constitutional Court, so I will be watching those with interest. There's also scope for judicial review of the government regulations in the Supreme Court, although they will need to wait some time for the Constitutional Court cases to conclude before they can begin. I do have a full paper available on this topic. It's been accepted to the Asian Journal of Comparative Law, and I'm happy to share it with anyone who would like to read it. Thank you very much for listening, and I look forward to questions and comments later in the Q&A session.
Okay, thank you, Dr. Petra.
Thank you.
That's wonderful. And the argument is the implementation of omnibus law. The law on job creation is a significant evidence to recent democratic decline or even regression. So your presentation shows us that there are many problems in Indonesia. So there are many issues that are interesting to handle dealing with our research. Okay, let's move to Dr. Muhammad Helmi Muhammad Said. Please, Doctor.
Can you hear me? Hello.
Okay, that's good.
Is it good?
Yeah, that's good. The second one is good, better.
Thank you. Very good morning. Okay, I would like to thank you, the introducer, Dr. Hasnan, the committee of INCLA, the Dean of Faculty of Law, Rector of Universitas Muhammadiyah Malang, okay, for inviting me, okay, to give a speech regarding the restorative justice and how to balance with the human rights. Okay, I would like to share my screen first. Allow me. Okay. Okay, today my topic is the balancing human rights and restorative justice and the study case for compulsory attendance orders and Indonesia. Before we go to my topic, I would like to mention to you that Malaysia, okay, has adopted, okay, the way, okay, how to restore the justice by introducing, okay, the offenders, okay, compulsory attendance order act, okay, 1951, okay. However, even though the act is quite old, but it seems, okay, nowadays, okay, the government encourage, okay, the court, okay, to adopt this way, okay, because we do not have enough, okay, prison, okay, to imprison the offender, especially the petty offences. That's why we adopt, okay, the restorative justice, the way, okay, how to cultivate, how to cater this problem, right? Basically, okay, when we are talking about the restorative justice, okay, of course it involves with the offenders, victim, and the communities. And the restorative justice also emphasize, okay, the human rights and the need to recognize the impact of social and the substantive injustice, and in a small way, it addressed this rather than simply provide offenders with a legal or formal justice and victim with no justice at all. And also, the restorative justice program tend to focus on measuring whether the victim, offender, and community representative are satisfied with the process and the outcome of the sentence. Okay, and when human rights have been more directly examined in relation to restorative justice, there has been a tendency to focus on the values evident in rights norms and protocols rather than undertake a systematic analysis of their nature and justifications. Okay, now today I would like to share with you the experience. Okay, how Malaysia has deal with it. Okay, with using the compulsory attendance order. Okay, and it is a type of the sentence that is stipulated under the Malaysian law, which is known as the Offenders Compulsory Attendance 1954. According to our federal constitution, okay, we have the Article 5, Section 1, no person shall be deprived of his life or personal liberty save in accordance with law. Okay, it shows that it is important to note that the both human rights and restorative justice policies are intended to deal with the matters of justice. Okay, human rights concern the minimum entitlements due to a person because of their humanity, and restorative justice is based on the reparative procedure. Okay, moving on to the compulsory attendance order is an alternative to imprisonment imposed by the court to offenders who committed certain offences to serve sentence outside the prison by performing compulsory work without disrupting his or her daily life. Convicts under the CAO are obliged to come to attendance center every day as ordered to conduct compulsory work sentence within 3 months at most, and for a duration of not exceeding 4 hours or for every single day. And also, this CAO or compulsory attendance order is imposed on the first-time offenders who committed minor offences such as petty, shoplifting, riding motorcycle, without license, and now government has encouraged to the court to use this act to impose the sentence those who are breaching the SOP for the pandemic season right now. But it seems it's quite very good because nowadays the citizens abide by this rule. In other words, CAO provide chance for the convicts to integrate into community and promote family and the society values. However, if the offenders breach the conditional order, while such sentence they could be convicted for the offense of breaching compulsory attendance order that is the punishable with the imprisonment. So it shows that moving on to the provisions under the Offenders Compulsory Attendance Act 1954, and I would like to highlight some important provisions only. According to Section 2 of the Act, defines the compulsory work as any labor, task, work, or course or instruction ordered by a compulsory attendance center officer to be undertaken by the offender. Moreover, according to the Section 4, states that the Director General shall appoint a superintendent of prisons or an officer in charge of a prison, either by name or office, to oversee each center, and the such superintendent or officer shall be known as the compulsory attendance center officer and in charge of such center. And according, okay, this is the most important section, section 5, subsection 1, okay, provides the circumstances in which CAO could be given, okay. According to this section, if someone, okay, has been convicted of an offense for which he is liable to be sentenced to imprisonment, or is liable to be committed to prison for failure to pay a fine or debt, so the court may consider factors such as character, type, and gravity of the offences or other circumstances before giving an order of compulsory attendance against the offender. In addition of this section, okay, the Act, okay, empower this section, okay, provide that if the court thinks it is expedient to punish the offender with imprisonment, the court may replace, okay, the sentence or suspend the sentence by making an order compulsory attendance, okay, require that the offender is present at the mandatory attendance center specified in the order on a daily basis, okay. And according with the sections 5, subsection 1 also, okay, when the offender is ruled to undergo such punishment, this offender must undertake to perform a mandatory work for a term not exceeding 3 months and for a specific number of hours per day, and not exceeding 4 hours as may be stated in the order. And also, okay, the court also has been vested the power, okay, to ensure the compliance of an order by this offender, okay, by requiring, okay, the offender to enter a bond with without guarantor. However, okay, it is necessary to note that before issuing an order of the compulsory attendance, okay, the court shall explain to the offender not give a sentence of the CAO unless, okay, the offender stated his consent to comply with the requirement of the order. Now moving on to the another section, which is, I think, is very important, and under the section 6, okay, which states that the offender shall, okay, upon the effect of such order, report on a daily basis at a time and place as ruled by the officer of the compulsory present with regard to circumstances of the offender. And if the offender, okay, shall undertake a mandatory work assignment as may be directed by the officer of the center of this compulsory attendance every day, okay, the work shall be, in the opinion of the officer, executed, okay, by the offender considering the physical ability the offender. However, okay, according to the section 8 of the CAO, okay, an offender is deemed, okay, to have committed an offense under the compulsory attendance if the offender's, okay, action fall under any of the headings below, okay. First one is fail, okay, the offender fail to on any day to report, okay, in accordance with the under the section 6, subsection 1, and also fails on any day to undertake or to complete the tasks that have been done by that committee, and in any way misconduct himself during the time when he is should or be undertaking compulsory. Maybe he wants to do something else, okay, which is not under the requirement, okay, so he will be punished, okay, under this section. And the last one is the fails in any way to comply with any of the requirements of the compulsory attendance order. Hence, okay, the mandatory attendance center, okay, official, okay, conduct the investigation against the offender. So the task is for the attendance center, okay, the mandatory attendance center, to observe, okay, the offender that had been sentenced under this act. I would like to share something about the section 7. So it's very interesting also, okay. Section 7 also provides that if the offender is injured, okay, due to an accident happened during the execution of compulsory work, he is entitled to receive medical and hospital treatment for free as may be prescribed. And now moving on to the legal responses, okay, how the court deal with the offense that relate with the CAO. Okay, there are two main principles in applying CAO towards the accused. Okay, the first one, the court shall be in a situation that it seems fit, okay, to consider an alternative that had it not been for this act, the court would have reasonably imposed an imprisonment sentence of not more than 3 months of an offense charge. And furthermore, okay, apart from the accused character and the nature of the offense, the court should also consider the effectiveness of the punishment sentence in upholding of the justice. Okay. Okay, there are several cases that is very quite very interesting that I want to share with you. Okay, the first one is in the case of the public prosecutor against T. Kim Kok. Okay, this case actually is an appeal case at the High Court of Sabah and Sarawak. Okay, against the imposition of the CO under the Offenders Compulsory Attendance Act. Okay, in this case, okay, the respondent in this case were accused, okay, of an offence under the Section 379A of the Penal Code for trying to steal, okay, a car, and by removing that cable, okay. The main issue arose was whether there exists a list of certain type of the offences under the 1954. Okay. However, in this case, the court held that Section 5 of this Section 1954 is the only applicable in situation where the court believes that imprisonment of not exceeding 3 months is sufficient. However, based on facts of this case, both were accused of attempted theft under the section which read together with the Section 511 of the Penal Code, which it is a very serious crime, and the minimum punishment for such offence is a year of imprisonment. So therefore, the imprisonment sentence of not more than 3 months was neither desirable and nor relevant, okay, to be used in determining the CAO in this case. Therefore, the court allowed this appeal case and set aside the magistrate CAO sentence. Okay. Now moving on, the second case. Okay, this case is very quite interesting because it involved the chief minister in one of the state in Malaysia. Okay, whereby the appellant in this case was charged under the Section 165 of the Penal Code, which is involved with I think it's bribery. Okay, and the main question in this appeal case was.
Doctor, 1 minute.
Okay, thank you. Okay, this was the punishment issue. Okay, in granting the alternative sentence order, it is important for the court to consider whether there is a particular situation or condition that justify imposition of such order by virtue of Section 5. And therefore, the court in this case was of the view that there were no extenuating circumstances of the offence, okay? And the trial court was right to pass a custodial sentence, not the non-custodial sentence, okay? Because this offence is very serious, so therefore CAO cannot be imposed for this crime, right? Okay, generally, okay, the compulsory attendance order, or widely known as the CAO, is a form of sentence and alternative to imprisonment sentence. And offender who has been convicted of minor offences, okay, he is required to report his presence at the payroll center before performing community work, okay, such as cleaning public areas. Okay, however, there are several suggestions that can be considered to ensure efficacy of the COS and the alternative punishment. The first one is the by incorporating COO into the criminal procedure code. Second, the cooperation with the other government agency. Thirdly, application of COO for road traffic offences. For enhancement of skill and training for CAO curriculum. And the last one is the creation of the occupational system standard. Okay, with that, I end my speech, but I have given my full article to the committee, okay. Participant can ask my paper from the committee. Okay, thank you.
Thank you, Dr. Helmi. Ladies and gentlemen, thank you. Sorry. Okay, let's begin the first Q&A session. If you have any question, please raise your hand or just add your question in the Q&A chat box. Okay, please, if you have any question, please raise your hand or just add your question in the Q&A chat box. Okay. Well, it's a big issue. Ladies and gentlemen, if there is no question, I'd like to invite all speakers to give their opinion dealing with the possible prediction or implication, or conceptual implication based on their primary arguments or intellectual reflections on it. The first speaker, Dr. Hilaire, you have 2 minutes to share your knowledge. Yeah, please.
Excuse me, I did not get what you said. What was your question?
Okay, this is invitation to all speakers to give opinion dealing with the possible prediction or implication based on the primary arguments that you have.
Okay, thank you. I heard you. My what I can offer as an insight probably would be the situation in Indonesia regarding access to justice and human rights and the rule of law. I think I was clear in my presentation. I said the Indonesian society is already leading towards restorative justice, as I did sufficient research on the customary law and the relationship between the states and the customary law. I think there's a great chance that justice can be enhanced, can be promoted through a different way, meaning restorative justice, because the society is inclined toward that direction. So I think the government should promote these means of justice-seeking alternatives to improve the access to justice in Indonesia. It would be my take on your question. I don't know if I answered that correctly, but yes, thank you.
Please, Dr. Petra.
Thank you. Well, I guess my primary argument resolves around the issue of whether or not we can see a democratic decline or illiberal turn in Indonesia in the last few years. And when we look at leading indexes around the world, so democratic indexes measuring democracy, we can see a decline occurring in Indonesia. My paper, though, I think is more aimed at the kind of legal detail and what's happening below the surface to try to look at this larger question. And I think that is one of the arguments I want to make, that sometimes we do need to look down deeply at what's happening in the detail as much as the larger picture of political, the larger political landscape. As for a prediction for the future, well, as I mentioned, we are waiting on the outcome of Constitutional Court judicial review challenges to the law on job creation. I'm not really brave enough, I don't think, to try to predict what the court will find in these. The first two cases were dismissed pretty much on technical terms rather than on substantive arguments. Yes, I don't know. I think predictions of the future is a very risky thing for an academic to do. So I think I'm going to just sit on that one and not make any strong predictions. Thank you. I think that's my answer.
Thank you very much. Let's move to Dr. Helmi. Although Dr. Helmi already highlighted some recommendations, Dr. Helmi, would you please to give us your intellectual reflection dealing with this issue of,
thank you.
Yeah.
I would like to respond with the from you. Okay, regarding this, I think in my paper, I feel that the restorative justice paradigm offers an ethical advantage over conventional criminal justice, in that offenders are treated as moral agents, in recognizing that wrongdoers, have moral obligations, especially in Malaysia, we recognize, their status as agents and not things, as subjects and not the objects, this is crucial to treating them with the respect that all humans deserve. And we argue that the fundamental human rights, such as dignity, respect, which I discussed earlier, the foundation values in the most conceptualization of restorative justice. Therefore, while the potential exists for the offenders to be treated respectfully and with the dignity as a moral agent, there is equally the potential for this agency to be undermined through offenders being caused or being forced to participate in the restorative justice process. Therefore, I give my suggestion, a few suggestions, to enhance what has been stipulated in that provision under the CAO rules. That's all. I think I answered it. And my hope is that the prediction in the future, I hope all three elements, the communities, the victim, and the offender, the values can be integrated in order to enhance in making the society at large to be in the harmony, to live in the peace and harmony. I think that's all from me.
Dr. Helmi, excuse me, we have a question from Adinda Putri.
Yeah, sure.
For Dr. Petra. But we have only 2 minutes. Yes, please, Adinda.
Yeah, thank you, Mr. Hasnan. So I want to ask to Dr. Petra Mahy from her previous presentation, she mentioned that there are major amendments in labor cluster, which consist the employer amendments and pro-worker amendments. So I am interested in the pro-employer amendments, which said no longer any restrictions on type of work that can be outsourced. So I want to ask, in your opinion, if there's no restrictions, especially in outsourcing works, do you think that it will improve the workers' right or even vice versa? And what kind of consequences you predicted going to happen if this one of amendments is implemented? Do you follow me? Yeah.
Yes.
Thank you.
Thank you for your question, Adinda.
Yeah.
I definitely think that this is a pro-employer amendment. And that means essentially that it reduces worker protections in this aspect. I think taking away the restrictions on what types of work can be outsourced is worrying, because it is likely to increase the amount of outsourcing that occurs in Indonesia. And we know that in practice, this often means reduction in working conditions for those workers who are outsourced compared to those who are insourced or employed directly. So I think this is one of the main problems with the Omnibus Law in terms of decent work protections in Indonesia. And I can see very clearly why the union movement has been very upset about this particular change in the law. So I think it is one of the major, it's a problem we need to watch for certain, to try to find out how employers are responding to it and what the implications are for Indonesian workers. So yeah, it's a great question and something that is of great worry, I think.
Okay.
Thank you very much.
Thank you, Dr. Petra. Thank you very much for the speakers at this first session. Fortunately, we have to end this session. Thank you, Dr. Hilaire, Dr. Petra, and Dr. Helmi. Ladies and gentlemen, we're gonna have 5 minutes break for before the second session of this program. Thank you. Assalamualaikum warahmatullahi wabarakatuh.
Fakultas Hukum Universitas Muhammadiyah Malang merupakan salah satu fakultas tertua di Universitas Muhammadiyah Malang. Dalam perkembangannya, sebagai penyelenggara pendidikan hukum, Fakultas Hukum Universitas Muhammadiyah Malang tidak hanya memberikan teori kepada mahasiswa, akan tetapi juga menempa mahasiswa dengan berbagai praktikum mata kuliah, pendidikan latihan, dan kemahiran hukum, serta memberikan kesempatan magang bagi mahasiswa, baik wilayah regional Jawa Timur maupun di tingkat nasional. Hal ini sebagai upaya Fakultas Hukum UMM dalam membekali mahasiswa agar mampu bersaing secara nasional maupun global. Kebijakan pimpinan universitas yang secara progresif mengembangkan konsep UMM pasti dalam merespon perkembangan dunia pendidikan tinggi juga sangat selaras dengan visi Fakultas Hukum untuk mewujudkan sarjana hukum yang profesional, humanis, dan religius.
Assalamualaikum warahmatullahi wabarakatuh. Saya Dr. Tongat SHM, Dekan Fakultas Hukum Universitas Muhammadiyah Malang. Dalam rangka merespon dan menghadapi tantangan global yang kian sengit, Fakultas Hukum Universitas Muhammadiyah Malang mengukuhkan eksistensinya melalui visinya, yaitu menjadikan Fakultas Hukum yang terkemuka dalam penyelenggaraan pendidikan tinggi hukum yang berkeunggulan di bidang penguasaan dan penerapan ilmu hukum untuk menghasilkan sarjana hukum yang profesional, humanis, dan religius. Berbagai upaya pengembangan Fakultas Hukum Universitas Muhammadiyah Malang diorientasikan juga untuk mewujudkan konsep UMM pasti, yaitu pasti lulus dan pasti kerja.
Fakultas Hukum UMM memberikan kesempatan kepada alumni untuk mengembangkan keilmuannya dengan memberikan pelayanan kepada masyarakat di Pos Bakum Pengadilan Agama Kabupaten Malang. Fakultas Hukum juga mampu menghasilkan alumni yang tangguh dan dapat bersaing di dunia global.
Assalamualaikum warahmatullahi wabarakatuh. Saya Komisaris Polisi Sunardi Riono, jabatan sehari-hari Kepala Bagian Operasional Polres Malang. Saya bangga menjadi alumni UMM. Saya angkatan 1987. Apalagi dengan perkembangan UMM yang sekarang ini, sudah pasti saya merasa bangga saya sebagai alumni UMM atau Universitas Muhammadiyah Malang. Sesungguhnya saya ingin banyak berkontribusi kepada alma mater, karena banyak sekali sesungguhnya kejadian-kejadian atau permasalahan hukum yang saya temukan di masyarakat yang seharusnya bisa dikembangkan melalui riset, melalui seminar dan lain sebagainya di dunia perguruan tinggi. Insya Allah apabila ada mahasiswa yang membutuhkan untuk penelitian dan sebagainya, saya siap untuk membantu. Terima kasih Fakultas Hukum UMM. Wassalamualaikum warahmatullahi wabarakatuh.
Banyak prestasi akademik yang ditorehkan mahasiswa Fakultas Hukum, diantaranya juara debat konstitusi, baik di tingkat regional maupun nasional, serta berbagai prestasi lainnya. Selain di bidang akademik, Fakultas Hukum UMM juga mendorong dan mendukung prestasi mahasiswa di bidang non-akademik, yaitu di bidang sepak bola.
Nama saya Bagas Dewi Caksono, mahasiswa Universitas Muhammadiyah Malang, dari Fakultas Hukum dan angkatan 2017 semester 4. Saya memilih Fakultas Hukum Universitas Muhammadiyah Malang seperti yang diketahui karena Fakultas Hukum Universitas Muhammadiyah Malang dan di sana banyak talenta-talenta pesepak bola yang sangat handal, dan saya memilih itu karena saya pribadi dan teman-teman tertarik atas sepak bola sebagai hobi saya dan pekerjaan saya, dan ingin menjunjung tinggi nama Universitas Muhammadiyah Malang. Terima kasih Fakultas Hukum Universitas Muhammadiyah Malang. Salam sejahtera, salam olahraga. Wassalamualaikum warahmatullahi wabarakatuh.
Saat ini, Fakultas Hukum UMM menjadi salah satu fakultas yang menyelenggarakan pendidikan khusus profesi advokat yang bekerja sama dengan Peradi Kota Malang.
Assalamualaikum warahmatullahi wabarakatuh. Perkenalkan, saya Iwan Kuswardi, Ketua Dewan Pimpinan Cabang Peradi Malang Raya, yang selama ini sudah sering melakukan kerjasama dengan Fakultas Hukum Universitas Muhammadiyah Malang. Beberapa kerjasama yang kami lakukan membuahkan hasil yang sangat luar biasa. Bagi mahasiswa yang ingin praktek magang di Peradi Malang Raya, beberapa kali mereka juga sudah melakukan kegiatan-kegiatan bersama Peradi Malang Raya. Pada saat Peradi Malang Raya menginginkan satu inovasi, mereka memberikan satu inisiatif, yakni membentuk organisasi bantuan hukum atau yang biasa dikenal dengan LBH. Selamat buat Fakultas Hukum Universitas Muhammadiyah Malang. Wassalamualaikum warahmatullahi wabarakatuh.
Hospital.
Okay, Mr. Hasnan, maybe you can continue the plenary session.
Thank you. Okay, Assalamualaikum warahmatullahi wabarakatuh. Ladies and gentlemen, we are now with Dr. Fifik Wiryani and Dr. Catur Wido Haruni. Dr. Fifik Wiryani is a lecturer at the Faculty of Law. Sorry. Sorry. Test. Okay. Dr. Fifik Wiryani is a lecturer at the Faculty of Law, the University of Muhammadiyah Malang. She was graduated from the doctoral program of University of Gajah Mada, Yogyakarta, Indonesia. Her specialization is land and agrarian law, and her current publication is Agrarian Law, Concept and History in Bahasa Indonesia, Hukum Agraria, Konsep dan Sejarah Hukum Agraria Era Kolonial hingga Kemerdekaan, published by Stara Press 2018. Her current research is on regulations of recognition and protection on ulayat rights of indigenous peoples in Indonesia. Dr. Catur Wido Haruni is a lecturer at the Faculty of Law, the University of Muhammadiyah Malang, and she holds a doctoral degree from the Faculty of Law, the University of Jember, Indonesia. Her specialization is legal system, legislation, and politics of law. Her most influential work is the local government administration law, history, concept, and current issues, published by Stara Press 2016. Her current research focuses on the reconstruction of the system of Indonesian Parliament's authority. And the first speaker at this second session will be Dr. Catur, right? Yes. Yes, please, Dr. Catur.
Ladies and gentlemen, Assalamualaikum warahmatullahi wabarakatuh. Share screen. Okay. Sudah. Okay. Thank you. As this distinguished academic program, I would like to deliver my presentation. The title of my research, The Construction of the System of Indonesian Parliament's Authority. It would be divided into three parts. The first is introduction, the second is discussion, and last but not least, the conclusion. Ladies and gentlemen, constitutional amendments still leave unfinished homework, namely the restructuring of state institutions in a dual format. The crucial problem that we will highlight, there are some desynchronized articles within the Indonesian Constitution relating to the Indonesian Parliament Authority. Amendment to the 1845 Constitution of the Republic of Indonesia. The MPR consists of members of the DPR and DPD. DPR is politic representation and DPD as regional representation. The MPR has different functions from the DPR and DPD. DPR and DPD function almost the same, but the council has limited functionality. So, the question arises whether the system of representative institution in Indonesia is a monocameral system or bicameral system or tricameral system. Ladies and gentlemen, for that we see the authority of the Indonesian Parliament, in this case, between the DPR and DPD, DPR and DPD authority relation, first authority in the field of legislation, second authority in the field of structuring or supervision, third of the authority in the field of consideration. The relationship of authority between DPR and DPD regarding the authority and function of the DPR are regulation in Article 20 and Article 21 in the Constitution Indonesia. The authority of the DPD is regulated in Article 2D and Article 23(5). Observing the role of the DPD and DPR and Constitution of the Republic Indonesia, so that the DPD is only a complementary institution because the DPD is carrying out its function is not completed and is always related to the DPR. So DPD is not a full legislative body. Carta Frederick states that Parliament is a representative assembly, legislation is its main function. The DPR is positioned as very dominant political institution because all the result on the structuring carried out by the DPD must be submitted to the DPR. And what is the follow-up to the result of the DPD? In such condition, the supervision carried out by DPD is unless. Constitutionally, the function of the budget lies with the DPR, starting for drafting, discussion, and approving bill into law. So, the position of the DPD is always related to the position of the DPR, as can be seen in the working relationship of the two institutions, where the status and authorities of the DPD are not completed with him, but are always connected with the status and authorities of the DPR. The final decision, if the field of legislation, supervision, and consideration rests with the DPR. What condition like this is so that two institutions of the DPR and DPD do not work in the corridor equality and balance. In general, it contrasts that under the beginner model, between one room and another room has the same function, namely in the field of legislation and supervision of the running of government and equality relation, and what distinguishes it from in the method of formation. Ladies and gentlemen, on other aspect, the unequal position of the DPR and DPD are also stated in Article 7C of Constitution Republik Indonesia, which states that the President may not freeze and dissolve the House of Representatives. In instance, in a presidential governmental system, the President cannot freeze and dissolve the DPR. Can this mean that the DPD can be dissolved by President? Ladies and gentlemen, finally, I present closing with consists of conclusion and recommendation. It is reserved one to conclusion. First, from institutional perspective, the structure of the Indonesian Parliament can be categorized and bicameral, but when viewed functionally in the making of legislation, the Indonesia parliamentary system can be categorized and unicameral, because the holder of power from the law on House of Representatives, the position of the DPD and the DPR in the field of legislative function is not equal but unequal. Second, the bicameral system has check and balance between the chamber of the representative body. Meanwhile, the relationship between the DPD and the DPR is asymmetrical in nature and does not reflect the principle of the check and balance system. Ladies and gentlemen, and recommendation this research. First, the construction of the MPR. The MPR concerns of the DPR and DPD, not member. Second, in the bicameral system, the two institutional have the same position. In the field of legislation, supervision, coordination, the position of the DPD need to full equal or no brought at the DPR. Three, amendment to Constitution of the Republic of Indonesia are implemented comprehensive and holistical in relation to article of the position and authority and function of the MPR, DPR, and DPD, and the President. Thank you. I think enough.
Dr. Catur, that's a very nice presentation. Let's inviting Dr. Fifik. Excuse me, Dr. Fifik, I'd like to invite you to speak, please.
Thank you, Mr. Hasnan. Assalamualaikum warahmatullahi wabarakatuh. Today, I would like to present my research with the title Criticism of Land Procurement Act for the Development of the Public Interest in Improving the Welfare of Landowners in Indonesia. In order to create a just and prosperous society based on Pancasila and Constitution, national development in various sectors are needed. To drive economic growth in national and regional development, one of the government's efforts to develop the country is by building infrastructure for public interest. In developing this infrastructure, land is a major component that plays an important role and determines the success of value in developing public interest. But in these developments, the state cannot provide sufficient land, so it then takes the lands belonging to the community, either from land owned by individuals, legal entities, or indigenous people. On the other hand, ownership of people's land is a human right that is protected by both international and national laws. During in 2014 to 2018 in period of President Jokowi JK, various infrastructure developments have been successfully carried with a total value worth more than 2,000 trillion rupiahs. Their infrastructures, as can be seen on the screen. Next. The following is the details of infrastructure development that have been completed from 2016 to 2019. For Indonesian people, land has multidimensional values such as cultural, economic, social, political, defense, and security. Based on the status of its use, it is distinguished between free state land, which is publicly controlled by the state, and private land, which is owned or controlled by individuals or legal entities, community groups, or indigenous peoples. Ideally, all infrastructure development is carried out on state land, but the fact is that the land needed for the construction of this massive infrastructure cannot be met from state land alone. So, the state must take the land from the people. On the other hand, ownership is also part of human right that protected by international and national law. So that, for the sake of public interest, land owned by the community can be taken by the state in various ways, namely, buying the transfer of the land rights based on treaty law, of voluntary release of land right by owner based on UUPA, Agrarian Act, and revocation of land rights by the state, and last, land procurement. In land procurement, many problems in implementation. There are 6,218 cases, criminal cases, and 4,810 civil dispute cases. This article have three main problems that talk about: one, discussing the regulation of compensation assessment; number two, legal analysis on deliberation of compensation determination; and number three, legal analysis of deposit land procurement compensation in the district court. The result of compensation assessment. Compensation assessment regulated in Article 31.1, Paragraph 1, about appraiser determination unilaterally that done by land agency. The problem in this article is appraiser determination unilaterally that done by the land agency, which has double role as an agrarian government agency and as land acquisition committee. Formulation of this article potentially reducing appraisers' independence that prone to land agency intervention. The alternative of article is appraisers are determined by the land agency based on the agreement between landowner and government agencies that need land. The next article in 34 paragraph 1, it states the compensation value assessed by the appraiser shall be the current value when the construction site determination for public interest is announced. The time spent between from location determination, compensation payment, and relinquishment of land right is 354 work days. Compensation value arrangement, a current value when construction location is announced, that regulated in Article 34 paragraph 1 is potentially reducing landowner welfare due to a surge in land prices. We recommended amend article. The compensation value assessed by the appraiser as referred in Article 33 should be the current value based on the high base use principle when the compensation is given. The second idea about deliberation of compensation determination. A topic this deliberation is time on deliberation of compensation determination and reject the offer of compensation from the land agency by the landowner. The problem of article in 37 paragraph 1 that state limitation on the deliberation time as much as 30 working days start when the pricer submit the assessment result to the land agency. The problem of this article is limitation on the deliberation time as much as 30 working days starts when the appraiser submit the assessment result to the land agency under Article 37 paragraph 1 is reducing a sense of deliberation and only formally done to about obligation rather than substantively done to obtain win-win solution. Careless deliberation arrangement also appear on Article 39 that refuse compensation offered by land agency. However, not raising objection means they have received the compensation offered. Provision Article 39 may seizing land covertly. Alternative this article is appraisers are determined by the land agency based on the agreement between landowner and government agency that need land. Article 39 talk about reject the offer of compensation from the land agency by the landowner. This article talk about concerning landowners reject compensation from an all amount but do not submit an objection within the time legally the landowners are deemed to accept compensation from an all amount. Careless deliberation arrangement also appear on Article 39 that refuse compensation offered by land agency. However, not raising objection mean they have received the compensation offered. Provision Article 39 may seizing land covertly. So we recommended Article 39 should only be deleted. And next, consignment land procurement compensation in the district court. About bid refusal of compensation of land by owners. Regarding the landowners reject compensation from an amount based on the deliberation result or district court or Supreme Court decision, then the compensation is deposited and the local district court. The problem this article 42 paragraph 1, the landowner who refuses compensation based on deliberation that does not produce an agreement or bets on a court decision and he does not take compensation money that is consigned in court, legally the land remains his property. Alternative article. In Article 42, the moment when the compensation and waiver implementation are done as referred in Article 41, paragraph 2a, or the compensation has been deposited in the district court as referred in Article 42, paragraph 1, land ownership or land right are abolished. The evidence of their right is declared invalid and the land is directly controlled by the state. The last slide, conclusion. Formulation in Article 31, 34, 37, 39, 42 and Article 43 of Land Acquisition Act inconsistent with its principles that should be used as a guide in the each article formulation. Besides, the article provisions are disharmony with Constitution, especially in Article 28G paragraph 1, Article 28H paragraph 4, Article 28G paragraph 1, MPR Decree number 17 in 1998, Article 32, Human Rights Act, Article 36, paragraph 1 and 2, Basic Agrarian Act, Article 18, Article 27A, paragraph 1, Article 34D, and Article 30D and Land Right Revocation Act. To ensure legal certainty in relation justice and prosperity the problem, article need to be harmonized. Thus, it provides legal certainty in land acquisition implementation. Therefore, objective of Land Acquisition Act established are realized. That my presentation. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you very much, Dr. Fifik. So, based on your argument, what you're gonna do? Would you do the judicial review? Okay, ladies and gentlemen, we turn to the second Q&A session. If you have any question, please write your name, a specific speaker that you will address the question and adding them to the Q&A chat box, or please raise your hand and speak straightforwardly. Please. Okay. Okay, there is no question. Okay, well, ladies and gentlemen, once again, we turn to the second Q&A session. If you have any question, please write your name, speaker, the question, and adding them to Q&A chat box, or please raise your hand and speak straightforwardly. Okay, there is no question. Well, let's inviting Dr. Catur and Dr. Fifik to give reflection based on based on your research. Such a last statement. Okay. 2 minutes, ya. Ya, boleh bahasa Indonesia. Silakan Bu Fifik.
Terima kasih. Mohon maaf in Indonesian. Tanah merupakan kebutuhan dasar manusia, semua makhluk hidup perlu itu. Dan kepemilikan tanah merupakan hak asasi manusia yang itu tidak boleh diganggu oleh siapapun termasuk oleh negara. Sehingga kepemilikan tanah itu merupakan bagian dari human right, bagian dari hak asasi manusia yang itu dilindungi oleh konstitusi kita dan semua aturan internasional yang ada. Untuk pengadaan tanah, ini sebaik rekomendasi yang kita perlukan adalah perlu dilakukan amandemen terkait undang-undang pengadaan tanah sehingga tanah itu benar-benar untuk sebesar-besar kemakmuran rakyat bisa dirasakan oleh semuanya, semua bangsa Indonesia. Tidak ada lagi pengambilan tanah secara paksa dari siapapun oleh siapapun. Itu penutup dari saya. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Terima kasih Dr. Fifik for your last statement at Bahasa Indonesia. Please, Dr. Catur. Indeed, we have a question from Dr. Bapak Danggur. Before you answer the question, would you please, Dr. Catur, to give your last statement? It's
best.
Like, yeah, please.
Bahasa Indonesia. Thank you, Mas Hasnan. Tema yang saya angkat berkaitan dengan rekonstruksi ya, sistem parlemen. Jadi amandemen Undang-Undang Dasar 45 ternyata masih banyak menyisakan pekerjaan rumah bagi bangsa ini. Mungkin akhir-akhir ini banyak rumor juga yang akan melakukan atau melanjutkan amandemen kelima. Tapi untuk melakukan amandemen lanjutan atau amandemen Undang-Undang Dasar Negara Republik Indonesia ini tidak bisa secara parsial ya. Jadi amandemen itu harus secara komprehensif. Jadi tidak bisa parsial hanya akan merubah pasal tertentu karena kita tahu bahwa pasal-pasal yang ada di dalam Undang-Undang Dasar 45 itu masih ada yang belum sinkron antara satu dengan yang lain, ada yang belum disinkronisasi. Ya, kenapa? Karena amandemen pertama 1, 2 dan 3 sampai 4 itu dilakukan secara adendum. Maksudnya apa? Begitu selesai amandemen 1 tutup. Jadi begitu amandemen kedua tidak buka lagi yang 1. Contohnya tadi terkait dengan DPR dan DPD. DPR itu amandemennya pada amandemen pertama. Sedangkan DPD ya, jadi DPD itu baru ada pada amandemen ketiga. Sehingga terkait dengan fungsi yang ada pada kedua lembaga ini dalam koridor tidak setara dan tidak seimbang. Kalau kita akan menentukan, ya kata bangsa ini pada saat amandemen itu akan memilih bicameral system, minimal antara kedua lembaga ini memiliki fungsi yang sama, karena kita tahu bahwa lembaga legislatif itu fungsi utamanya itu kan fungsi legislasi. Tapi kalau fungsi legislasi ini hanya ada pada DPR, DPD itu kan hanya sebagai co-legislator ya, sehingga dalam sejarah bangsa kita suatu saat nanti kita tidak akan menemukan di dalam produk yang namanya undang-undang itu nama DPD nggak pernah ada. Yang ada hanya DPR dan Presiden. Itu oleh karena itu amandemen, jadi kalau kita akan menata kembali sistem perwakilan di Indonesia memang harus dilakukan secara komprehensif ya. Jadi kita akan melakukan amandemen itu ya juga menata MPR-nya juga. Karena MPR kita itu kalau di dalam pasal 2 ayat 1 itu MPR terdiri dari anggota DPR dan anggota DPD. Sehingga kalau nanti ada amandemen pun ya, karena syarat untuk amandemen itu kan 2/3 suara ya anggota. Jadi anggota DPD hanya 1 itu bisa. Oleh karena itu selama ini DPD berapa kali tahun 2007 itu pernah mengusulkan untuk amandemen, tetapi ya kalah. Jadi untuk memperoleh suara 2/3 dari majelis tidak tercapai gitu, karena sebagian besar ya anggota di MPR itu ya orang-orang DPR yang jumlahnya 500 sekian, kemudian DPD jumlahnya hanya 136. Jadi untuk melakukan amandemen kalau sendiri ya tidak mampu ya, tidak tercapai lah. Oleh karena itu terkait dengan kelembagaan MPR pun juga harus di amandemen. Jadi MPR itu tidak anggota, jadi tidak bicara anggota tapi harus bicara tentang lembaga. MPR terdiri dari DPR dan DPD. Ya seperti kalau di Amerika itu Kongres terdiri dari House Representative dan Senat itu. Ya mudah-mudahan nanti kalau seandainya ada amandemen ya harus menata kembali kelembagaan negara ya. Jadi tidak hanya parsial misalnya membahas tertentu saja, tapi harus ditata semuanya ini ya. Ini memang pekerjaan yang cukup berat ya kalau akan melakukan perubahan terhadap undang-undang dasar, dan yang terpenting tidak ada istilahnya itu kepentingan ya. Kalau kita melakukan perubahan undang-undang dasar itu memang harus berpikir untuk ke depan ya, berpikir untuk seluruh anak bangsa dan negara. Jadi tidak berpikir untuk kepentingan golongan tertentu, itu yang terpenting. Terima kasih. Assalamualaikum warahmatullahi wabarakatuh.
Assalamualaikum warahmatullahi wabarakatuh. Thank you, Dr. Catur. Actually, the amendment of the Constitution, based on Dr. Catur opinion, depends on the political dynamics among political parties in the country. So, I'd like to invite, before we move to Dr. Abustan, Dr. Dangur, would you please to turn on to unmute your microphone? Dr. Dangur, do you still there? Excuse me, Dr. Dangur. Okay, let's move to Dr. Abustan. Please, Dr. Abustan. Excuse me, Dr. Abustan. Hello, do you still there?
Hello.
Okay.
Hello.
Please. Oh, please,
Hello.
Dr. Dangur. Yeah, it's clear.
Indonesia speaking. Pertama, saya sampaikan terima kasih kepada pembicara terakhir ya. Tapi tujukan kepada Ibu Catur dengan saya lupa tadi, mohon maaf. Dalam permasalahan tanah Indonesia, ya di Indonesia itu memang menjadi problem hak masyarakat kita. Ada ketidakadilan antara kepemilikan tanah, di mana di dalam laporan-laporan mengenai kepemilikan itu 2%, ya. Kepemilikan tanah Indonesia dikuasai oleh orang tertentu dan dia menguasai 80%, sedangkan kita yang asli cuma 20%. Nah, pertanyaan saya, tanah-tanah yang sekarang itu dikuasai secara melanggar hak, ya, artinya saya mengatakan melanggar hak. Bagaimana konsep Ibu Catur di dalam mengembalikan hak-hak mereka itu sehingga ada kesetaraan hak antara warga. Jadi tidak ada diskriminasi atau seperti yang Ibu sampaikan bahwa tidak dikuasai.
Mohon maaf,
oleh
Dr. Danggur, bisa on cam?
Gimana saya lanjut pertanyaan tadi, moderator? Terputus nih tadi. Haji Abustan.
Dr. Danggur, ya, thank you.
Ya. Bagaimana konsep Ibu sebagai pemikir atau sebagai konsep untuk mengembalikan hak-hak rakyat terhadap tanah yang sudah dikooptasi oleh 2% warga ini. Nah, konsep regulasinya seperti apa atau politik hukum pertanahan seperti apa yang akan dibangun sehingga terjadi kesetaraan kepemilikan tanah. Jadi yang 2% menguasai 80% tanah di Indonesia itu menjadi ada kesetaraan terhadap rakyat. Itu saja. Terima kasih. Terima kasih, moderator.
Terima kasih, Dr. Danggur. Ladies and gentlemen, before we move to Dr. Abustan, let's speaker to answer the question first before we move to Dr. Abustan.
Thank you.
I give you 2 minutes for Dr. Fifik and 2 minutes for Dr. Catur, please.
Makasih.
Ibu bisa menjawab dalam bahasa Indonesia.
Thank you, moderator yang kedua kalinya. Saya dikasih kesempatan.
Terima kasih atas pertanyaannya.
Ini bertanya dulu atau gimana nih, moderator?
Dijawab dulu ya, Dr. Abustan, dijawab dulu agar kita fokus. Thank you.
Terima kasih. Kalau kita lihat di konstitusi kita, terutama pasal agraria, yaitu yang ada di pasal 33, itu sesungguhnya kan sudah jelas. Bumi, air, ruang angkasa, dan kekayaan alam yang terkandung di dalamnya dikuasai oleh negara untuk sebesar-besar kemakmuran rakyat. Nah, tentu dikuasai oleh negara di sini tidak dalam pengertian dimiliki, tetapi penguasaan dalam pengertian publik, negara sebagai wakil dari bangsa Indonesia. Nah, dalam perjalanannya kemudian memang nampak ada disparitas kepemilikan, kesenjangan kepemilikan tanah yang sangat tinggi. Kenapa itu terjadi? Kita tahu bahwa yang punya kewenangan untuk mendistribusikan, memberikan atau apapun kepada siapapun tanah-tanah yang ada di Indonesia adalah negara. Sehingga itu tergantung dari bagaimana kebijakan negara. Sesungguhnya kalau secara normatif, secara yuridis, kita sudah punya aturan larangan kepemilikan tanah melampaui batas. Itu misalkan yang ada di dalam Undang-Undang Land Reform, yang itu sampai sekarang belum pernah dihapus, dan itu bagus. Tetapi saat ini yang kalau saya mencermati fakta yang ada, banyak tanah-tanah itu hanya diberikan kepada segelintir orang atau badan hukum yang itu diberikannya sangat luas. Jadi di sini kalau saya melihat ada kurang kepekaan dari pimpinan atau dari negara, pimpinan negara kita untuk bagaimana mestinya kan yang diutamakan adalah bangsa Indonesia, yang diutamakan masyarakat yang tidak, masih banyak masyarakat kita yang tidak punya tanah untuk tempat tinggal, sehingga dia harus tidur di emperan toko dan lain-lain. Nah, sehingga kalau itu bisa dilakukan, itu kenapa tidak? Sehingga rekomendasinya laksanakanlah program land reform itu dengan baik, terutama apa? Redistribusi tanah-tanah. Tanah apa saja yang diredistribusi? Nah, tanah-tanah yang banyak milik pelaku usaha yang luasnya sampai ratusan atau bahkan ribuan hektar itu banyak yang tidak terolah. Nah, itu kan bertentangan dengan fungsi sosial hak atas tanah sesungguhnya, dan itu negara punya kewenangan untuk mencabutnya. Jadi itu menurut saya, Bapak. Terima kasih.
Ya, untuk donai.
Oke, terima kasih Bu Dr. Fifik. Saya ingin mengundang Dr.
Saya bisa langsung, moderator?
Ya, boleh, Dr. Apustan, singkat, padat, jelas, langsung. Terima kasih. 1-2 menit. Oke.
Thank you, terima kasih. Saya kira pertanyaan saya yang pertama tentu pada narasumber yang pertama, yaitu yang menyoal soal reformasi kelembagaan, ya. Seperti kita tahu bahwa reformasi tentu di samping semangatnya, spiritnya adalah reformasi juga kelembagaan, ya. Dan salah satu diantaranya buah daripada reformasi itu adalah menghadirkan lembaga Dewan Perwakilan Daerah (DPD). Pertanyaan saya kira memang saya sependapat bahwa sudah berjalan setelah dievaluasi sekarang, kelihatan sekali optimalisasi apalagi namanya fungsi dan wewenang lembaga DPD ini itu sangat apalagi namanya sangat tidak maksimal. Itu karena faktor itu tadi, bahwa memang ada kesan bahwa kehadiran lembaga ini banyak sekali hal-hal yang strategis justru dihilangkan. Padahal kalau kita mengacu pada kiblat negara yang mempergunakan itu bicameral, ya, seperti Amerika Serikat, itu memang balancing kelembagaan itu sangat kelihatan, ya. Jadi power antara DPD dan DPR itu memang seimbang, sehingga tidak ada lagi hal-hal DPD itu tidak batasannya cuma sampai di sini, ya, dia hanya bisa memajukan, tetapi yang mengikuti sidang tentang budgeting dan lain sebagainya itu tidak bisa. Nah, saya kira dalam kondisi sekarang ketatanegaraan kita ini, ya, ini menjadi kebutuhan masyarakat, di mana fungsi DPR yang juga dilihat tidak maksimal, sehingga ada dominasi kekuasaan itu pada eksekutif. Jadi apa yang diletakkan oleh John Locke soal trias politika itu sangat tidak memadai diperankan oleh DPR. Ada kepincangan di situ. Oleh karena itu saya kira ini momentum untuk mendorong DPD ini menjalankan fungsinya secara maksimal. Ya, apalagi kita lihat regulasi-regulasi yang ada di pemerintahan daerah itu sangat, ya, boleh dikata overload, ya, undang-undang pemerintahan daerah. Oleh karena itu saya kira desentralisasi ini harus juga dibarengi optimalisasi peran daripada DPD yang memang secara khusus konsen adalah mengawasi atau mengawal soal pemerintahan yang ada di daerah. Jadi oleh karena itu saya kira saya sependapat untuk dilakukan amandemen, tapi dengan itu tadi memang benar-benar harus diletakkan fungsi DPD ini sama seperti acuan semula seperti di Amerika. Saya kira
Dr. Apustan, pertanyaannya?
Ya, pertanyaannya ya tentu bagaimana apalagi namanya amandemen kelima ini, saya tidak perlu khawatir, Amerika aja udah ratusan kali melakukan amandemen konstitusi. Nah, untuk itu bagaimana menurut narasumber bisa mengakomodir benar-benar aspirasi supaya DPD itu bisa lebih optimal menjalankan kewenangannya, fungsinya. Terus pertanyaan yang kedua, untuk yang menyoal soal pertanahan, saya kira ini juga suatu permasalahan yang sangat urgent karena kita lihat bagaimana ketimpangan pola penguasaan tanah itu, saya kira itu tidak equal ya, bahkan tidak fair. Nah, oleh karena itu menyangkut hajat hidup orang banyak, di situ saya kira harus diberikan perlindungan ya. Aspek HAM-nya harus lebih ditonjolkan di situ. Oleh karena itu pertanyaan saya kira undang-undang agraria saya kira perlu dipikirkan. Kita lihat Undang-Undang Nomor 5 tahun 60 itu sudah cukup lama. Indonesia yang begitu luas ya, kok sangat mengecewakan kalau sistem hukum kita yang tahun 60 ini masih tetap saja kita perlakukan sampai sekarang. Sementara di sisi lain kondisi pertanahan ini, keagrarian ini sangat carut marut. Oleh karena itu saya kira amandemen selanjutnya perlu dipikirkan ya, bagaimana meletakkan supaya jangan ada lagi monopoli kepemilikan atau penguasaan tanah ya, yang hanya segelintir atau sekelompok kecil saja bisa menguasai ratusan hektar ya, yang ada tanah yang ada di Indonesia ini. Atau paling tidak bagaimana land reform ini ya dilakukan lagi inventarisasi ulang ya.
Oke,
jangan terlalu
Dr.
banyak.
Agustan, kami menangkap bagaimana agar supaya tidak ada penguasaan tanah yang terlalu banyak.
Oke,
itu pertanyaan untuk narasumber kedua. Ya.
Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. I will pass to Dr. Catur, Dr. Fifik. Please,
1 minute.
Ya, 2 menit masing-masing.
Ya, oke, terima kasih. Tadi dari Pak Dr. Hasbutan itu pernyataan ya. Jadi pada dasarnya kan sepakat untuk melakukan amandemen untuk menguatkan ya, penguatan atau optimalisasi fungsi dari DPD, karena secara konstitusional fungsi DPD itu kan istilahnya kurang menjamin kepastian hukum, karena di dalam pasal 22D terkait dengan kalimat hanya mengatakan DPD dapat mengajukan ya rancangan undang-undang yang terkait, ada 5 bidang itu, ada 5 bidang ya, terutama yang berkaitan dengan masalah otonomi daerah, terkait dengan pemekaran, dan ada 5 bidang. Tetapi semuanya itu kan hanya diajukan ke DPR, makanya DPD itu kan seperti ko-legislator ya, jadi tidak sampai kepada tahap ikut mengesahkan suatu undang-undang. Ini yang memang sangat memprihatinkan ya, di mana DPD itu secara legitimasi itu kuat tetapi secara fungsi lemah, sehingga banyak yang mengatakan sangat anomali ya kedudukan DPD ini ya. Jadi oleh karena itu perlu ditata sistem parlemen di Indonesia ini ya, supaya kinerja ya, adanya DPD itu ya harus istilahnya jangan sampai adanya sama dengan tiadanya gitu loh. Oleh karena itu memang harus dikuatkan ya fungsinya ini, meskipun itu hanya bidang tertentu yang terkait dengan otonomi daerah. Kemudian dalam Undang-Undang MD 3 itu ada tambahan fungsi DPD di dalam Undang-Undang Nomor 2 2018, yaitu terkait dengan pemantauan dan evaluasi perda dan raperda. Secara konstitusional kalau dicari itu kan sebenarnya nggak ada itu, tapi mungkin itu terkait dengan kepanjangan tangan dari pelaksanaan dari undang-undang. Sehingga kalau akan melakukan penguatan undang-undang ya bisa juga melalui Undang-Undang MD 3 atau dalam jangka panjang memang melalui Undang-Undang Dasar. Jadi Pak Dr. Agustan ya sepakatlah untuk melakukan optimalisasi fungsi DPD. Terima kasih.
Ya.
Terima kasih Dr. Agusta. Saya sepakat bahwa kalau menurut saya negara perlu melakukan evaluasi terkait dengan penguasaan tanah. Itu yang pertama. Sudah betulkah penguasaan tanah yang dimilikinya atau dikuasainya itu sesuai dengan kebutuhannya atau tidak? Di sana ada disparitas atau tidak? Itu yang pertama. Yang kedua, tentu ini harus melibatkan stakeholder ya, itu terkait dengan evaluasi penguasaan tanah. Sehingga kalau nanti yang seperti saya katakan tadi, tanah itu ternyata hanya sebagai objek investasi saja, tidak diolah dan seterusnya, ya sebaiknya ya itu bisa dilakukan, ditetapkan sebagai tanah terlantar dan itu bisa diberikan kepada masyarakat yang membutuhkan. Yang kedua adalah perlu juga kita sebetulnya sudah ada aturan tadi luas maksimum kepemilikan tanah. Nah, apakah itu sudah dilakukan atau tidak? Sudah dievaluasi dengan baik atau tidak? Nah, inilah akar masalah yang memunculkan kemudian konflik-konflik yang ada di lapangan. Begitu juga banyak masyarakat yang menguasai seperti di Malang misalkan, banyak masyarakat yang menguasai bekas perkebunan yang sudah enggak dirawat, itu ternyata malah dikriminalisasi. Jadi kasus-kasusnya masih banyak yang seperti itu, masih tidak memihak kepada masyarakat kita. Padahal kalau kita balik lagi kepada UU-PA, memang UU-PA tidak semuanya baik. Tetapi paling tidak aturan terbaru dari hak atas tanah misalkan, sekarang jangka waktunya kan bisa kita mendapatkan tanah itu langsung diberikan sesuai jangka waktu, perpanjangan plus pembaharuannya. Nah, ini perlu dievaluasi. Lah, mestinya bertahap saja seperti sebelumnya. Berikan dulu sambil dilihat, sambil dievaluasi. Oh, kalau dia bermanfaat bagi semuanya, banyak orang, silakan mau diperpanjang. Oh, masih bermanfaat lagi, silakan diperbaharui. Tetapi yang terjadi sekarang kan langsung diberikan di muka. Jatah waktunya berapa, perpanjangannya berapa, plus pembaharuannya 3 kali lipat berarti. Sehingga aturan itu perlu direvisi, perlu dihilangkan kalau menurut saya. Ya harus bertahap sesuai dengan kebutuhan masing-masing. Begitu Pak Agus dari saya. Saya kembalikan kepada Pak Asnan.
Terima kasih Dr. Fifik. Alhamdulillah kita di penghujung acara. Thank you very much for Dr. Fifik and Dr. Catur and all participants. We wish that we will have the third INCLAR next year, 2022. So please preparing your best research paper to join us at the next program. Ladies and gentlemen, I will pass this program to Ocha. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Well, thank you, Mr. Hasnan, our gorgeous moderator, and also our speakers of today's agenda. Ladies and gentlemen, the plenary session is already done, so we please you to enjoy your break, and please, you can go back to the room, to the Zoom meeting within 15 minutes before 1 p.m. And then we will continue to another section of this conference with parallel session. So, thank you. You can enjoy your break. Wassalamualaikum warahmatullahi wabarakatuh.
The Great Malang area, which offers cool and comfortable weather, is a perfect location for learning, allowing students to keep growing and developing. Everyone will surely love this city. It is a dream place for all students from various cultures and countries. The University of Muhammadiyah Malang, UMM, is blessed with all sorts of natural splendours. This university is full of achievements. No wonder awards and acknowledgements keep coming from various institutions, both national and international ones. Among others are the highest A-list institutional accreditation from the Indonesian National University Accreditation Body, BANPT, and the award for the leading university from the Department of Higher Education Region of the 7th of East Java, which was achieved 11 times consecutively. In the global level, UMM achievement is also as great. UMM has twice been awarded the Asian Energy Awards in 2009 and 2018. In 2010 to 2011, UMM also achieved 2-star university from the internationally renowned institution. In addition, UMM has also been an associate member of the AUNQA, the Asian University Association. UMM students are highly heterogeneous. They come from all corners of the nation as well as overseas. There are 11 faculties and 57 study programs offered in UMM, starting from the diploma level, undergraduate, graduate to doctoral programs. Among those, 4 of UMM study programs have been internationally accredited and certified by the AUNQA. Some of the list of faculty and study programs in this university are faculties and study programs are equipped with high-standard laboratories, which are all centrally managed by the UMM Central Laboratory Office. UMM laboratories have achieved the International Standardization Organization (ISO) and the National Accreditation Committee, and so we are qualified to perform laboratory tests for other agencies such as companies or other universities. In addition to academic facilities, UMM also offers many business units which serve as the university income centres. Those business units allow the university to have more sources of income for its operational cost, thus we do not merely depend on the funding generated from the students. We have UMM Dome, UMM Hospital, Saya Medica Hospital in Samboa, UMM Gas Station, Motorbike and Car Workshop, Micro Hydro Power Plant, UMM Sang Saya Apartment, UMM Rinjani Credit Bank, UMM Farm Agriculture Production Centre, UMM Sangkaling Recreational Park and UMM Kapel Garden Hotel. All those business units also serve as the applied laboratories in order to boost UMM students' entrepreneurship skills. As an internationally reputable university, UMM is proud to have conducted many international outreach programs with various academic activities such as seminars, conferences, research projects, as well as student, staff and faculty member exchange programs with numerous overseas universities and institutions. So far, UMM has established active collaborations with 111 universities, as well as governmental and non-governmental institutions from a total of 31 countries around the world. Among others are UMM students and lecturers embraces creativity and innovation in developing their research and academic works, as well as to perform community service programs. This enthusiasm for working and innovating has been the main urge for UMM students of communication science major to renovate the slum area of Jolapan to be the colourful neighbourhood area, more commonly known in Indonesia as Kawasan Kampung Warna-Warni, which is renowned internationally, as well as to create the Tempunasor Green Neighbourhood, Kampung Hijau Tempunasaurus, located in Beji village, which is acknowledged by the Indonesian Museum of Record, MURI. On top of that, the robotic team of UMM has 3 times in a row won the International Robotic Competition in the US. UMM is also renowned for its energy independence. For more than a decade, UMM has established its own power plant, the Micro Hydro Power Plant. After gaining success in the university area, this power plant concept was expanded by establishing other micro hydro power plants in Sumbermarung, Kamasuku village, Malang Regency, and in the Boom Spring tourism area. This program has successfully established 4,000 electricity connections in the local resident houses. Success starts from the courage to dream and to move forward for better change. Your steps today determine your roles in the future, to be students and graduates who are ready to actively work and contribute for the nation. Students today, leaders tomorrow.